Today, I'll be showing you how to draft a deed of assignment. And we begin with just the introductory part. Now, the introductory part of a deed contains 4 clauses. The commencement clause, the date clause, and the parties clause, and the recital. Now, the commencement clause is a clause that tells you what the transaction is about. And for instance, in this example, it says this deed of assignment. If this was a mortgage, it would say this deed of mortgage. If it was a lease, it would say this deed of lease. The date clause tells you the date of execution of the document. Here we have is made this dash day of dash 20 dash. In some other examples, it would just say made without the is. And what's the difference between both styles? If you have is made, and that signifies that there's going to be a recital included in that draft. And generally, I'll just advise to always say is made and include a recital. All right, now what you would observe again in the date clause is that there is no date inserted in the draft. And what's the reason for this? Now, you know that after a deed is executed, it's also supposed to be registered, and stamp duties are also supposed to be paid. Supposed to be stamped. Stamp duties are supposed to be paid within 30 days of execution, and registration is supposed to be done within 60 days of execution. But before you can do that, and the governor needs to grant his consent to the transaction first. Now, if you date the deed and send it off to the governor to grant his consent, now depending on how long it takes, by the time you receive it back, you may already be in default for stamping within 30 days or registering within 60 days. And so you don't date it until it's returned from the governor, and then you now insert the date in the deed. So that's the date clause. Now the parties clause between Chief Ishola Peters of 2 Broad Street, Lagos, a signer of one part, and Mr. Soli Samba of 32 Victoria Avenue, Lagos, a signee of the other part. So it describes whom the parties are in the transaction. It provides their names, their addresses, and then their designation in the transaction, whether they are a signer or a signee. Now, how about where you have a company as one of the parties in the transaction? How do we insert the name of the company? Now, if you have a company as a party, it would say something like XYZ PLC. So let's say between Mr. Ishola Peters and XYZ PLC, a company duly registered under the Companies and Allied Matters Act 2020 with RC number ... and registered address at so and so place. All right, so if you have a company as a party in the transaction, that's how the name of the company will be inserted. And then finally, we come to the recital. Now, the recital is simply just drafted as whereas, and then in numbered paragraphs, a brief history of the transaction is provided. All right, so all you just insert there is whereas, and then some history is provided on the transaction. Now, when you're drafting for your exams and other purposes, you won't need to start manufacturing some facts to include in a recital, as long as you just have the whereas and then have ellipses underneath. All right, so just ... and that's fine. Now, but why is a recital important? Indeed, a recital is important because it provides, as you can see, some background on the transaction, and it also is important because it can be used for interpreting other parts of the deed and could help in clearing up any ambiguity. And according to the Evidence Act, you'll also see in Section 165 that when you have documents that are over 20 years, then the facts contained in the recital of such documents are presumed to be true, except if the contrary can be proved. All right, so that's the importance of having a recital, and that wraps up the introductory part of a deed of assignment. Again, it's the commencement clause, the date clause, the parties clause, and the recital.